Good afternoon, everybody. Thanks so much for joining us. Today's workshop with Kim Martin is going to be turning 18 in special needs land. This video will be recorded and it will be available on the Focus website under recorded workshops at the end of the week. And for anyone that has any questions, feel free to add that to the chat box and Kim will answer those at the end of the presentation. Otherwise, it's an absolute pleasure to welcome Focus Mom and Kim Martin. Kim, take it away.
Thank you, Jade, and thank you, everybody, for taking time out of your day to listen to this talk. So as Jade mentioned, I am a Focus mom of many years. My son, Finn, is 17 now, and we have been going to the camps and doing a lot of the educational experiences for parents and things like that for many years. So we love Focus. I am also an attorney. The name of my firm is Harrison LLP, and my entire practice is devoted to working with families that have a child with special needs. I do special needs planning. I do guardianships when our kids turn 18. That's one of the things we're going to talk about today. And I also work in consultation with divorce lawyers who have a divorce happening where there is a child in the mix who will someday be on benefits. So that is what I do. And before we really get started on the talk today, I have to do my little disclaimer. So the purpose of this meeting is purely educational. So nothing that I say today should be construed as legal advice. I don't have any information about anybody that's out in the audience today. So really all I can do is give you general educational information. Any opinions that I express during this talk are purely my own opinion, and I am not speaking on behalf of any other entity. And finally, and I think most importantly, this meeting is not a substitute for a sit-down meeting with an attorney who knows all about you and your family and can answer specific questions and give you advice that's related to what you need in particular. So all we can do today is give general information, although I believe we will be answering questions later. So there are lots of things that happen when our kids turn 18. The first two things on this list are fairly easy to deal with, so that's why I put them first. But when your child turns 18, there are lots of things that you either need to do or perhaps should do. The first one is registering your child with the selective service. You only need to do this if you have a male child. So only males need to register at age 18. This is registering for the draft, basically. And you don't have an exemption if your child is disabled. So even if you know that your child would never actually be drafted, you still have to register them for the draft. And then if there is a draft and if your child gets drafted, that's when you would claim the exemption for disability. The way that you would register is you can either go online and get a form that you can print out, and that website is here, or you can go to the U.S. Post Office and get SSS Form 1 and fill that out and send it in. If you don't register your child for the draft, there's a fine of $250,000, and there might be a prison term of up to 5 years. So it's a pretty big deal. Make sure that you register your child for the draft when they turn 18. Another thing that you could do when your child turns 18 is you apply for benefits. That's the Georgia Supplemental Nutrition Assistance Program. It's what we used to call food stamps. For some reason, everybody is chomping at the bit to apply for SSI, and a lot of people just don't really think about SNAP benefits, but it's something that your child is probably going to be entitled to at age 18. In some counties, there is a work requirement in order to get SNAP benefits. And in other words, you have to show that you are working at least part-time. That requirement is often waivable if your child has a condition that makes it impossible for them to work. In order to qualify for SNAP benefits, your child has to have net income that is below the poverty line. And because at age 18, our kids are considered to be a household of one for benefits purposes, your child is by himself a household. So the net income requirement would be for the poverty limit for one individual person. I think this year that's something like $12,700 a year in income, but I could be off by a little bit. And this benefit is means tested, just like the other benefits that we're going to talk about today. But while the means test for SSI and Medicaid is $2,000, SNAP benefits are payable if you pass an asset test of $3,750. So if your child passes the means test for SSI and Medicaid, then you're fine. You'll also pass the means test for SNAP. The maximum amount that you can get for SNAP benefits is $250 a month. It could be less than that, and they will make the determination as to the amount that your child gets based on a formula where they look at resources and income and other things. And it's when you get SNAP, it's just a plastic debit card. It looks like any other debit card or credit card, and you can go to the grocery store and buy your groceries and pay with your SNAP card. That's how it works. So the way that you would apply is you can either go online to this website here that's on this slide, or you can call the SNAP Customer Service Contact Center. I will say I tried calling this number just to see what happens, and I was on hold for about 25 minutes and finally gave up. So I am not telling you that anybody's going to answer if you call this number, but that call if you have a lot of time on your hands. So another big thing that people consider when their children turn 18 is it time to apply for guardianship and or conservatorship? So once our kids turn 18, legally, they are adults, which means they can sign contracts and get married and do all kinds of other things that might not necessarily be a great idea. So if you're not sure whether you want to apply for guardianship or conservatorship of your child, guardianship is care of the person. So it's making medical decisions. It's deciding where the child is going to live. It's parenting, basically. And guardianship is appropriate if the proposed ward, that would be your child, cannot make or communicate significant responsible decisions about their own health and safety. Conservatorship is care of the person's money. It's care of assets. So conservatorship is appropriate if your child has assets. So if they own nothing, then it doesn't make any sense to apply for conservatorship, and you don't have to ask for both. But assuming that your child has assets that are subject to conservatorship, then, and they can't make or communicate significant responsible decisions concerning those assets, then it's appropriate to apply for conservatorship. Keep in mind that not all of the assets that you might consider your child's are subject to conservatorship. So, for example, many of the probate courts in Georgia have come to land at the position that assets in an ABLE account are not subject to conservatorship. It's also well established that assets in a trust are not subject to conservatorship, and that's because we have a trustee who has a fiduciary obligation already to take care of those assets. And by the same token, if your child is on SSI or any other Social Security benefit, And if you or somebody else is the representative payee for that Social Security benefit, then that benefit is also not subject to conservatorship. And that's because the rep payee, just like a trustee, has a fiduciary obligation to take care of that Social Security money and to account to Social Security for it. So, assuming that your child meets those requirements for a petition for guardianship or conservatorship, if you're on the fence about whether you want to go ahead with that petition, the things to think about are here on this slide. First of all, intellect plays a big factor. So if your child has an intellectual disability and they have trouble understanding things like contracts that they might need to sign, that could be a reason to petition for guardianship so that you can make those decisions on behalf of your child. If your child lacks critical thinking skills, if they will just do anything that anybody tells them to because they were raised to behave and be obedient and listen to adults that tell them what to do, we don't want your child to get manipulated or just instructed to do something that's not in their best interest. So if that's the case, guardianship might be appropriate. Communication skills are a really big deal. Remember that our standard for guardianship is that the proposed ward can't make or communicate significant responsible decisions about their own safety or care. So if your child has trouble expressing himself, or if perhaps they have an anxiety disorder or something that affects their ability to communicate, or if there's a physical barrier to them communicating with people and being able to express their needs and wants and wishes, it might make sense for you to petition for guardianship so that you can speak on behalf of your child. There are some medical conditions that particularly send parents running to petition for guardianship the minute that they can. So, for example, if your child has something like a seizure disorder, where at any time they could need emergency medical care, once your child is 18, if that happens, nobody's going to deny treatment to your child, but they probably won't share test results with you or let you find out what's going on from the doctor. And they certainly are not supposed to be letting you make decisions on behalf of your child. So if your child has some sort of a medical condition that requires potentially frequent emergency care, that might be a good motivator to petition for guardianship. And then finally, how much opportunity does your child have to get into trouble? So if you have a child who is with you or a caregiver that you trust 24 hours a day, 7 days a week, that means that there's always going to be somebody there to look after them and keep them safe. If you have a child who is able to have a job or go to a day program or do volunteer work or live separately from you, then there might be a little more opportunity for somebody with bad intentions to come along and exploit your child in some way. So the more opportunity there is for that, the more likely it is that it's a good idea to petition for guardianship and conservatorship. So if you do petition for guardianship or conservatorship, there are certain rights that will be removed from your child, assuming that you're successful in your petition. And the first one is the right to marry, meaning if you're under guardianship, they cannot legally marry. Even if they run off and get married and come home and say, I got married this weekend, you can say, no, you didn't, because legally they don't have the capacity to marry. They also no longer have the legal capacity to enter into contracts. So if they sign a contract, it's meaningless. It has no legal effect and your child is not bound by it. Your child would also lose the right to decide where to live. That doesn't mean that you can decide where your child is going to live and then handcuff them to the bedpost. They are free to come and go, but you decide where they live. Your child also loses the right to consent to medical treatment if they're under guardianship. There's a little asterisk next to that because that has a lot of qualifiers. So while you as the guardian would have the right, and in fact, the duty to consent to medical treatment on your child's behalf, that doesn't mean that you can force your child to submit to treatment that they don't want to submit to. So that's the first thing under the rights that your child retains under guardianship. They have the right to refuse medical treatment. So you might choose a course of treatment, and that is your job as guardian. But if your child says, I don't want that shot, I don't want that surgery, I don't want to take that pill, you can't force them to unless it's an emergency situation. So your child also always retains the right to seek legal advice and to retain a lawyer to contest the guardianship if they feel that they shouldn't be under guardianship. Almost always, the child retains the right to vote. I've seen that taken away only one time. So generally, they will retain the right to vote. And assuming that they can pass the driving test, just like everybody else has to, they retain the right to drive. If your child has the capacity to understand what they're doing, then they will still have the right to make a will and the right to participate in decisions that concern them, even though you might be making those decisions. So there are a lot of urban legends that surround the issue of guardianship. And these are some things that I hear a lot. And so I've just kind of compiled them all into this slide so that we can address them. If your child is under guardianship, that is not a get out of jail free card, which means if they commit a crime, they can still be arrested. They can still have to go in front of a judge for a hearing or a trial. And if they're found guilty, they can still be put in jail. But having said all that, if your child is under guardianship and there's some altercation or some kind of contact with the police, when everybody understands that they're dealing with a person who's incapacitated, that person tends to be treated differently. People tend to be more patient. They tend to give them the benefit of the doubt. So, I'm not saying that being under guardianship will get your child out of trouble, but I think if your child is under guardianship and they do have some kind of brush with the law, the fact that they're under guardianship is probably going to be a point in their favor, and they might be treated more leniently or more patiently. SSI has nothing whatsoever to do with guardianship, except that they happen to both be things that people think about when the child turns 18. So if you don't have a guardianship in place, if you have no intention of petitioning for guardianship, that has nothing to do with your child's ability to apply for SSI. You do not need permission from anybody to petition for guardianship. You don't need anybody's approval. You don't need a letter of recommendation or whatever. If your child sees a therapist or a doctor who says, I don't think he needs to be under guardianship and I'm not going to go along with it, it makes no difference whatsoever. They don't even have to be notified that you're petitioning for guardianship, and they don't get a vote. So this is really your decision. And if you're on the fence about guardianship because you feel like right now my child does need help making decisions, and I think it would be safer for my child not to have 100% of the rights that adults typically have, but maybe someday, if the meds get figured out, or if we keep on working on life skills, maybe my child won't need a guardian. So when you petition for guardianship, if the court grants your petition, they are granting a petition for permanent guardianship, but that doesn't really mean that it's permanent forever. Because if your child's condition changes in some way and you feel like they can make their own decisions responsibly, you can undo the guardianship by petitioning the court and just sort of arguing the opposite of the things that you argued in your petition asking for guardianship. So you can say, my child has developed the coping skills to take his meds on time. He's learned how to balance a checkbook and manage his money. He pays his own bills. He goes to the grocery store by himself. He makes his own meals. If your child gets to that place and you feel like the guardianship is no longer appropriate, you can undo it. And you do not have to have an attorney to petition for guardianship. It's not required. So sometimes people will hire an attorney because they just feel like this is complicated, or the idea of going to court themselves is stressful or whatever. But if you want to petition for guardianship yourself without an attorney, you can certainly do it. And the place to get started on that petition would be go to gaprobate.gov. And that is the website for all the probate courts in Georgia. So you'd go to that website, find your county, the county where your child lives, and click on that county. And then there should be a thing that says forms, and you click on forms, and there should be a list of court-created forms. And one of those forms will be the petition for guardianship over an incapacitated adult. So that's the petition that you would need to complete and submit to the court if you want to do this yourself. Okay, so another big thing that happens when your child turns 18 is that they may want to apply for SSI, Supplemental Security Income. In order to do that, to qualify for it, they have to meet the statutory definition of disabled. And for an adult, that definition is they have some type of condition that prevents them from engaging in paid work. It's called substantial gainful activity. So that doesn't mean your child can't have any kind of a job at all. They can't make anything. But if your child makes less than $1,470 a month, or if you have a child who is blind, it's $2,460 a month. That's the substantial gainful activity number for this calendar year, 2023. So if they earn, a few $100s a month at a part-time job, that's fine. They still meet the statutory definition of disabled because they're not engaging in substantial gainful activity. So assuming that they meet that definition, then they have to pass the means test. And the means test is a resource test. So that includes family resources until the child reaches age 18. And that's why a lot of our kids don't qualify for SSI until they reach age 18. Because once the child is 18, as I mentioned earlier, they become a household of one for benefits purposes, which means Social Security stops paying attention to what mom and dad have, and they only pay attention to what the child has. So assuming that your child personally doesn't have more than $2,000 in non-exempt resources, then they will pass the means test. So that's one of the steps in qualifying for SSI. And then finally, SSI is also subject to an income test, and that includes both earned and unearned income. So with an adult child, Social Security will disregard the first $20 of any income that they have in a given month. And then every dollar that they earn or any form of income after that will offset SSI dollar for dollar. So there are lots of different ways that you can have your SSI reduced or that you can lose your SSI. And these are some of the ones that happen the most frequently. So if your child lives with you, then Social Security might determine that they are getting in-kind support and maintenance, or ISM. The reason they care about this is because SSI is supposed to be for food and shelter. So there's this kind of ridiculous fiction that $914 a month is supposed to meet all of your child's food and shelter costs. And if your child is getting food and shelter from any source other than SSI or an ABLE account, then that's considered in-kind support and maintenance. And if your child is getting in-kind support and maintenance, then they will reduce his SSI by a third. So for this year, that means instead of getting the maximum of $914 a month, your child would get $609 a month. So this is something that happens often when your child lives with you if you're not charging them for their food and shelter. So the way that you can fix that is you can have your child sign a room and board agreement. And that's just a short little contract that says, I am charging you this much per month to live in your room and eat out of the refrigerator. So if you have your child execute a room and board agreement and you show that to Social Security, then they should determine that there is no ISM happening because you're not giving your child food and shelter, you're charging them for it. So you should be able to go back up to $914 a month. So if your child is under guardianship, of course, they don't have the capacity to sign a contract. So they don't have the capacity to sign a room and board agreement. But as your child's guardian, you can sign that agreement on their behalf. So another way that they may lose SSI is if they fail the means test, and this is determined as of the first day of any given month. So if your child has more than $2,000 in non-exempt resources on the first day of a given month, they will lose SSI for that month. So the quickest way to address that, if you have a relatively small amount of money, is to put that money into an ABLE account, which is an account, it's similar to the 529 college savings plans. In fact, ABLE accounts are created under a statute that's called Section 529A of the Internal Revenue Code. The ABLE account can hold up to $17,000 a year. Or if your child has income from a job, it can hold $17,000 a year plus any amount of earned income that your child has up to the poverty limit for that year. So if it's a fairly small amount of money and you just need to park it someplace quickly, an ABLE account is a great place to do that. And anything that you put into the ABLE account is going to be considered an exempt resource for benefits purposes. If it's too much money to get it into an ABLE account, then there's another option, which is to use a particular type of special needs trust. It's called a D4A trust, or sometimes you'll hear it called a first party special needs trust. So this is another exempt basket that you can put your child's money into. Keep in mind that both ABLE accounts and first party special needs trusts are subject to Medicaid payback at the end of your child's life. So that's the first money you want to spend. Both of these things are just parking spaces. So they're places to put money to make sure that your child passes the means test. But as soon as you have a need for that money, you should spend it. And then there are also income offsets like child support. People don't think about this all the time, but if child support is being paid for your child, once the child reaches adulthood, which is usually 18, the definition of an adult child depends in part on the circumstances, like are they still in school, that kind of thing. But whenever they reach adulthood, if child support is being paid for your child, then Social Security will disregard the first $20 of that child support every month And then if your child is a minor child, they'll disregard another 1/3 of the child support. If your child is an adult child, they'll disregard nothing. So they'll disregard the $20 and all the rest of the child support will offset SSI dollar for dollar and possibly wipe it out. And the way that you would address that is your settlement agreement would say that payments after the child becomes an adult are going to be made to a D4A trust. You can't use an ABLE account for this. It won't work. It has to be made to a D4A trust, a first party special needs trust. And as long as you do that, then the child support payments are not considered income to the child and they won't affect SSI. So when your child turns 18, very likely if they're on Katie Beckett will end because it's technically it ends at age 18, but there is a way to get Katie Beckett back in place for a year while you're in the process of applying for SSI. And once your child is on SSI, then they have regular Medicaid. So we don't need Katie Beckett anymore. But the way that you would keep Katie Beckett going beyond the age of 18 is you file for SSI. Social Security is going to give you an application summary. You take that application summary and you send a copy of it to the Katie Beckett unit. And that documentation should cause them to extend Katie Beckett Medicaid until either your child gets SSI or until they turn 19. So walking further down the path of benefits, assuming that your child qualifies for SSI, at some point, probably life events are going to happen that will cause your child to roll from SSI to SSDI. So the differences between these two benefits are, first of all, SSI is means tested and SSDI is not. SSI has a maximum monthly benefit of $914 a month for this year, 2023. SSDI can be more, and it kind of depends on how they qualify for SSDI. There are two different ways. If your child has enough quarters of work of their own, and then something happens and they become disabled in a manner that prevents them from being able to work, they could get SSDI based on their own work record. Or the better way to get it really is to get it through a parent's work record. So if your child has a disability that occurred before the age of 22, and then a parent either dies or retires or becomes disabled and starts to draw Social Security, if any of those things happen, then they can get SSDI based on a parent's work record. And typically that's more money because it's about half of what the parent gets. SSI, as we've already talked about, can be reduced or even lost if your child has too much earned or unearned income. SSDI doesn't care about unearned income. They only pay attention to income from a job. SSI will automatically get your child on Medicaid. SSDI is connected to Medicare. So 2 years after your child goes on SSDI, they will go on Medicare. And we've already talked about the ISM rules that could cause a 1/3 reduction in SSI. SSDI does not have those ISM rules. So we can use SSDI money for anything. It doesn't have to be for food and shelter. So I mentioned that SSDI is not means tested and Medicare is also not means tested, but that doesn't mean that we can ever stop worrying about the means test. We always care about the means test, even after we're no longer on SSI. And that's because of Medicaid, because there are so many different kinds of Medicaid. So the now comp waivers are the big kind of shiny brass ring of Medicaid. And while you're on the waiting list for a now comp waiver, there's something that you can get called family support, which is an annual budget that you get. It's $3,000. The state of Georgia has actually cut the family support budget. So right now, I think it's something like $1,800 a year. But if your child is on family support, that's sort of the state of Georgia's attempt to give them a little something while they hang out on that Now Comp waiting list. And it's a budget that you can use to pay for anything that will help your child to lead a more independent life. So it could pay for summer camp. It can pay for karate classes. It can pay for social skills groups that your child might want to participate in. It could pay for working out with a private trainer at a gym. So it's just a budget that you have that you can use for anything that will make your child better able to go out in the world and socialize and have an independent life. And later in life, if your child is in need of a nursing home level of care, they may want to qualify for nursing home Medicaid, which, just like it sounds, will pay for some or all of your child being in a nursing home. So all of these things are means tested. This is just a few examples of the different types of Medicaid that we might want. And so even after we are no longer on SSI, we always want to pay attention to the means test. So even though this talk so far has been about turning 18, there are some other ages that are significant. And the first one is age 22. That's a really big deal because at age 2, your child is no longer eligible to receive services from the public school system. So that means you have to become your child's cruise director. This is something that stresses me out. I have a 17-year-old and I have a few years to go, but I still think about this all the time. Once there's no more school to go to, one of the options that might be a good fit for your child is to find a day program. So that's often a combination of a social outlet and a way to get more life skills. They're all over Atlanta and they have, varying characteristics, but you may want to look into a day program for your child. Supported employment may also be a good fit for your child. So that means they might start by working with some type of a voc rehab organization that would go with them and be job coaches for them so that they can have some type of paid employment. There's also volunteer work. If your child loves to play with animals, they could go and work at the local animal shelter, or they could volunteer in a charity thrift store, or whatever other activities are going to make them happy and keep them busy and fulfilled. And then finally, also let your child find bliss. Let them play sports. If they like to play baseball, get them on an adaptive baseball team. If they love art, make sure that they have access to an art studio and art classes. If they love movies, get them involved with a group where they can go and watch movies together. Create a Pokemon playing group, whatever it is that your child loves. Just as a parent, one of the things that you can do to ensure that your child has a happy, fulfilling life is make sure that they have the resources and the time to indulge their hobbies. And then finally, another significant thing about age 22 is this is the oldest age for SSDI qualification based on a parent's work record. So if your child's disability occurred before the age of 22, that means that someday, if we have a parent who does any of those 3 things that I mentioned earlier, if they die, if they retire and start to draw Social Security, or if they become disabled themselves and start to draw SSDI themselves, any of those three things will trigger a rollover from SSI to SSDI, assuming that your child was disabled before the age of 22. So another significant age is 26, and that's because that is often when your private medical insurance that you might have through your work will no longer allow you to keep your child on the family policy. Up until 26, there's a disability exception that will let you keep your child insured. But after age 26, you may have to find another plan. So if your child doesn't have a job that provides medical insurance, then Medicaid or Medicare, depending on what type of Social Security they're on, may become their medical insurance. And if they don't qualify for any of those, then you may need to look at the marketplace and buy them a private policy. So this is just here because Focus has such fantastic resources. And if you poke around on their website, you'll find all kinds of great things. But one thing that is really helpful to look at if you do have a child who's approaching the age of 18 is you go to this website, focusga.gov. You click on how we can help you. Then you click on hope. Then you click on resources, and you'll see a place to click on. It says transition to adult services. So I would strongly encourage everybody to do that because Focus has a lot of great resources for young adults who are disabled and for their families too. So then there are certain things that are just events. They don't necessarily happen at any particular age, but they are triggering events that are going to cause a child's benefits. So I've got a slide here about those just to make you aware of them. So as I've already mentioned, if a parent dies, becomes disabled, or retires, that will potentially shift the child from SSI to SSDI. When your child rolls from SSI to SSDI, that means Medicaid will go away because SSI and Medicaid are linked. And Medicare isn't going to kick in until 2 years after your child qualifies for SSDI. So if you're in that situation, you can get Medicaid back. If the only reason that your child has lost Medicaid is because they've rolled from SSI to SSDI, there is an adult disabled child type of Medicaid that you can get to fill in that 2-year gap. If your child gets married, this has huge implications. So if your child is married, then they're not a household of one, and the means test changes for them. So instead of if your child is married to someone else who also was qualified for SSI, then they don't each have a $2,000 means test. As a married couple, they now have one means test, and that means test is $3,000 for both of them put together. So make sure if your child is married or is contemplating getting married to someone who is also on SSI or any other means tested benefit, you need to make sure that their combined resources don't exceed $3,000. Also, if your child gets married, the maximum amount they can get in SSI changes. So each partner doesn't get $914 a month. It becomes $1,828 a month for the two of them. So that's a 25% decrease in the total amount they can get in SSI. If your child is married, that means they can no longer roll from SSI to SSDI based on a parent's work record if one of those triggering events happens. And it also means that if you feel that your child is in need of a guardian, the child's spouse is statutorily the first person in line that the court will consider as a potential guardian. So that doesn't mean that your child's spouse has to become their guardian. If your child is married to somebody who isn't capable of serving as a guardian, then the court will not name them. But that's something that you would need to address in your petition for guardianship if your child is married. So that's all I have. I am happy to answer questions if anybody has questions.
Kim, thank you so much. Yes, if anyone has questions, please add them to the chat box. And Kim, the first question in the chat box is, your child is a household of one, even if they live with you?
Yes. When they
Perfect.
turn 18, they are a household of one, regardless of whether they live with you, regardless of whether they're still in school. A household of one at age 18.
Perfect. Brenda asked, what is the name of that form? Brenda, I'm not sure which
Which
form.
form?
Yeah, we were on. My child already turned 18 and already has SSI. Should she apply for adult SS?
I'm not sure what that means. So if your child is 18 and is on SSI, then that should also cause them to be on med. And I am not sure what the other kind of, are you maybe talking about? That will happen automatically if the circumstances are right.
Another question, Kim, is what if they are adopted?
Well, do you mean, are they still eligible for SSI? They're still eligible for SSI when they turn 18, even if they're adopted. They are still eligible to roll from SSI to SSDI, even if they're adopted.
How do I apply for family support is another question.
It depends what county you live in. The Bobby Dodd Institute serves a number of counties in Metro Atlanta. So if you live in Clayton, DeKalb, Fulton, Gwinnett, or Rockdale County, then you should contact the Bobby Dodd Institute. It depends. What you might want to do is Google family support for your county and then find the entity that administers family support.
Thank you, Kim. Another question, is this being recorded? Yes, this will be available on the Focus website under our programs. We have parent support, and that's where you can find recorded workshops, and that'll be up by the end of this week. Another question about how do we apply for family support? You just talked about that. And at what age should you begin applying for guardianship?
The earliest that you can petition is 6 months before your child's 18th birthday. You don't have to petition for guardianship when your child is 18. That's the earliest you can become a guardian, because until then they're a minor. So you're already in charge of them because you're their parent. But there's no age limit. I mean, I've done petitions for guardianship over people who are in their 40s. Usually that happens because mom and dad die and nobody's ever petitioned for guardianship. And then the siblings find out that it's really hard for them to get anything done because they're not the guardian. So, but there's no age limit. You can petition for guardianship over anybody of any age, but they're not in need of an adult guardianship until they are actually an adult, which is 18.
Thank you, Kim. Where can we find that form to apply for guardianship by themselves?
I'll scroll back here to get to that. It's gaprobate.gov. So that's the website for the probate courts of Georgia. I'm getting there. Did I miss it? I missed it. Hang on. Guardianship. There it is. Okay, it's at the bottom of this slide. Go to gaprobate.gov. And that'll get you, that's all of the probate courts in the state of Georgia. So then find your county, click on your county, and then there should be a thing that says forms. And if you click on that, you'll get this long list of forms, and they're all PDFs. They're kind of difficult to fill out, but one of the forms is the petition for guardianship of an incapacitated adult. And that's what you're looking for.
Thank you, Kim. Is there a checklist somewhere with all the information?
There is not. You mean all the information in this presentation? I wish there was a handbook, but this is my attempt to sort of corral the information. Hang on one second. Finn, I'm getting a talk, sweetie. Thank you. Sorry, that's my son.
You're fine.
I'll see
For,
what he wants in a minute.
for guardianship, can both mom and dad apply to be guardians, or is it just one parent?
You can ask for both parents to be guardians, keeping in mind that if there are two people serving as co-guardians, the court is going to regard those people as two halves of a whole. In other words, you can't say, okay, you take him to the doctor and I'm going to go do this other thing. You're always supposed to act together as a unit. So if you're good with that, then yes, you can be co-guardians, and courts are fine with that. But they are going to expect the two of you to act together. You can't divvy out the jobs and have one person do one thing and another person do something else.
Thank you, Kim. Linda's asking 914 plus 914 equals 1828. She doesn't see a 25% decrease in that.
You know what? I might have done my math wrong. That is entirely possible. So yes, I'm sorry about that. It should be 1828 then with times 0.75. And I think maybe I didn't do that because I was updating these slides from last year. Yeah, I did my math wrong. I'm sorry. There should be
No
a
worries.
25% decrease. Thank you for doing that and catching it, because now I'm going to fix it.
Another question is, what is better, SSI or SSI or SSDI, assuming that the parent is over 62?
Well, SSDI is usually more money because they do the math. This is assuming that the child is on SSDI based on a parent's work record. It's generally more money than SSI, and it is not means tested, and it's not subject to things like the in-kind support and maintenance rule. So SSDI is less of a hassle to have as a benefit. But also keep in mind, if you're thinking about retiring and drawing Social Security, the longer you wait, the more money you get. And that means our math is different for your child. So I'm not saying that you necessarily should wait. I'm just saying that's something to take into consideration. Your Social Security amount is going to get bigger if you wait later to take Social Security.
Thank you, Kim. And you already mentioned the name of the guardianship form. It's for petition for guardianship of the incapacitated adult, correct?
Mm-hmm.
Thank you. When can we apply for SSI? Do we have to wait for them to be 18 years old?
You don't have to wait for them to be 18, but they're probably not going to qualify until they're 18, because until they're 18, Social Security attributes all of your family's resources to your child. So hopefully you have more than $2,000, which means they're going to attribute whatever assets you have to your child, because those assets are available to take care of your child. So as a practical matter, our kids don't qualify for SSI until they turn 18. And that's because when they turn 18, they're a household of one. So we stop paying attention to what mom and dad have, and we only pay attention to what the child has. And the earliest you can file the application for SSI is after the child's 18th birthday. You can't file it until they're actually 18.
Thank you, Kim. Another question is, what if only one parent paid into SSI? Can the child still get SSDI based on one parent?
Yes. So, I mean, that's if only one parent paid into Social Security, so only one parent is entitled to get Social Security, then that parent would have to be the one who retires and starts to draw. But if that happens, then yes, the child could get SSDI based on that parent's work record.
Thank you, Kim. Another question is, are there any programs out there that will help with the cost or the fees of guardianship?
Well, I have heard of people, there are going to be fees for sure. There's usually the filing fees are around $700, even if you do it yourself. It depends on the county, so that's not an exact number. I have heard of people doing something called a pauper's affidavit, which is if you argue, this is for my child and my child doesn't have any money, so we shouldn't have to pay filing fees. I have never tried that. I don't know if it works, but you could Google pauper's affidavit and see what you find out.
Thank you, Kim. And then our last question today, is the adult child eligible for SSDI through a parent's employment for the child's lifetime?
Yes. So even after the parent dies, the child can still be getting SSDI based on that parent's work record. And if we've got two parents who have both worked and both have a Social Security record, if one of those people retires and starts to draw, and then the other person retires later and starts to draw, if the person who retired second was the higher earning person, they'll redo the math. So they will always do the math based on the highest earning parent who's making the child eligible. So it's possible, like if one parent retires and the child gets SSDI, and then the second parent retires and earned more and draws more in Social Security, the child's SSDI payment would go up.
Thank you, Kim. Well, that was the last of our questions. We greatly appreciate your time today and the time that you have for our families. Thank you for leaving your last slide up. That way, if anyone has any questions or wants a consultation with you, your telephone number is 404-567-4154. And that's kmartin@harrisonllp.com. So we just appreciate you and thank you so much for your time today.
It was my pleasure.
Thank you so much, Kim. We will see you in January at the Focus Educational Conference.
You will.
Thank you all. Have a great day.